Hi, this is Dr. Paula Duren, and I'm the Director of Universal Dementia Caregivers. And as you know, we have been increasing our presence online because we cannot come to you and support you in terms of training around dementia and dementia-related diseases. So our target audience is our caregivers, but our topic today is so much broader than that, that we have the pleasure of having attorney Eric Holmes with us today. And Eric is an estate planning and probate attorney. Let me first welcome Eric, Mr. Holmes. Can I call you Eric?
Yes, please.
Welcome to our discussion today. We're going to talk about wills and trust, but really the topic is your paperwork right? And we find ourselves in a time right now where many caregivers are loving on people, and in the process of caring for them, if they transition, they need to make sure they have the right paperwork in place. Not only if they transition, you need to know what the desires are now so that they can be supported now. And in this environment with the death rate being so high, I often say not only do we need paperwork for our caregivers, we need paperwork for ourselves that clarifies what we'd like to have done for ourselves. So welcome to the discussion, Eric. And I'm going to start out by just tell us a little bit about who you are and what makes you qualified to have this conversation.
Well, first of all, I want to thank you for having me here. It's a pleasure to talk to you and to address your audience. I'm an investment advisor. Have been since I got out of college about 31 years ago. That is my primary background, advising people with investments and financial planning. And one of the elements of financial planning is estate planning. So I've counseled people, and I knew enough to be dangerous as an investment advisor about estate planning. So a little later on, I went to law school, became an attorney, just for the purposes of kind of closing that loop and being able to advise and to develop wills and trusts, and help people with their estate planning part of their financial planning. What that led me into is as a financial planner, typically it covers the decedent estate part of financial planning, and that's what I knew the most about prior to becoming an attorney. But after you become an attorney, you start dealing with issues in the probate court. I got introduced to dealing with what you call living probate, which is guardianships and conservatorships, and that's a whole nother element. And the thing is once you start actually practicing in that area, you start to really see and understand the importance of having the documents that you've been drafting up for so many years. So that's where I am right now. I talk to people. I do try to encourage people to do wills, do trusts, make sure that the affairs are taken care of, after they pass away. But probably what's more important and what causes most of the issues and most of the controversy is not when you die, but when you don't die, but you need someone to kind of help take care of your affairs. And if you don't have that in place, that could be much more expensive. And, like I said, it's got to be dealt with one way or the other.
Right.
Whether you do it or not, it's got to get dealt with. And you might as well make it happen as efficiently as you can. And a lot of times when you don't explore it, you don't really understand, what is going to be the perfect habit. A lot of people make assumptions as to how things are going to work. And that's not always the case.
So my guess is you have a few horror stories of families that did not have paperwork to talk, where a loved one who may have become mentally incapacitated and didn't have paperwork. I know that we've seen families struggling with who's going to be in charge, whose name is going to be on the documents, how are we going to split up the money? I'm like, the person hasn't died and you're talking about how you're going to split up the money. Just some questions that are really premature, struggles over how the person would be cared for. just don't, I'm sure lots of stuff. Tell me a little bit about one issue you had to deal with as it relates to someone not having the proper documents, legal documents in place, that you personally had to help resolve.
Um, well, example, there was a client who I used, I dealt with her as an investment advisor. I tried to get her to get wills, trust, and it's one of those things where you don't think that you're going to be the one that loses your ability to take care of your affairs. She was a driver and took care of everything for herself. But when she started to lose capacity, she had a son who was out of state, and her son, came up here to physically bring her down to where he was so he can kind of take care of her, because she kind of lost the ability to take care of herself, obviously. So in the process of moving her down there, he went to the bank to try to take her money down there. And the bank, talked to her, they assessed her capacity, and they kind of discovered that she didn't, understand the nature of what she was doing. So that triggered them to kind of get the court involved with it.
Okay.
And they didn't let her take the money. Then the court got involved. They had a guardian ad litem. Is when it's obvious that a person has lost their capacity, the court will assign a guardian ad litem to kind of interview all parties involved. They'll, and if they're supposed to represent the interest of that protected party. And what they determined was that she needed to have some type of, a conservator and a guardianship. Well, the son, they, had a good family, good home life, everything. He was very suitable to look after her affairs. I mean, it was by clear and convincing evidence. However, to be her conservator, which is the person who oversees her finances.
And we can and we'll talk in more detail about the various roles,
right?
Because I'm going to want you to articulate each one for us.
Yeah. So
sorry for the interruption.
Yeah. So they determined that he wasn't a suitable conservator because of some things in his background. So as a result, they let him become the guardian. And she's got a court-appointed conservator who essentially doles out money to them for her care. Mm-hmm. And it's and this happens is that families will think that I'm taking care of the person, but I have no access to the money. And that's just one of those things that can happen. Now, even though he had the red flag that kind of popped up that precluded him from being a conservator, had she had her affairs in order in the first place, this would have never become an issue in the first place.
Okay. Let me just then step back and talk about when I consult with people, I tell them there are probably 5 documents that I think they need to make sure are in place that can possibly keep them out of probate. And I say possibly because people can take you to court regardless.
Yes.
So they're about 5, and I'm going to list them, and then maybe we could, if they're the ones you also use, you can talk about them one at a time. That you need a durable power of attorney. Mm-hmm. You need a will, mm-hmm. Or a living will that gives advance directives. Let's see, possibly a living trust, depending on the person and what they choose to do, and a power of attorney, because power attorneys can be legal, financial, and health, correct?
Yes. So
let's step backwards and first tell us, what is a power of attorney?
There's a durable power of attorney is a document that appoints someone to become your attorney. In fact, if you got to the point where you lose your mental capacity to make decisions on your own. So capacity is through some type of, mental deficiency. It could be elder. Also, capacity could be, a minor. So a person who is deemed not capable of taking care of their own affairs, when you set up a power of attorney, this document says that if I'm deemed incapacitated, then you name a person to step into your shoes and be able to do what you would do in terms of managing your finances and business. And you can give them as many powers as you want. You can give them discretion to do anything that you would do, or you can limit those powers. What I also do with those is you want to not only just have one person, you want to have an alternate in case that person is unwilling to serve,
Okay.
or unable to serve.
So once I select a power of attorney, is that my power of attorney the rest of my life, or can I change them?
Yeah, you can change it as long as you have the capacity and you have sound mind and you understand the nature of what you're doing. You can change it. Okay. Sometimes it has to change. And then the thing is once the person loses capacity, the person who you name as the attorney of fact has to accept that role, because he has some fiduciary responsibility. He may take on some liability if he's neglectful in his duty. So they have to accept the role, formally accept the role.
So is there a difference between a power of attorney and a durable power of attorney?
No, those terms are used pretty much interchangeably.
Okay, but they can cover legal, financial, and then health. Yeah,
well, that's a durable power of attorney. Now, the second one is a durable power of attorney for healthcare.
Okay.
And that's where that one particularly covers, if you can't make decisions regarding your well-being,
okay,
healthcare decisions. And also in the documents that I use, we have the advanced directives in there, where you would, kind of state your wishes as to, if you got to the point of a vegetative state, what would you want the person to do? So that has to do with healthcare. So the durable power of attorney covers finances. It covers taking care of business affairs. Durable power for healthcare covers the person, the well-being, medical. So it covers things like, where are you going to live?
Okay.
Medical decisions, what happens in case of death. And also too, it can cover, how do you want, do you, what type of final arrangements do you want? Whether it be cremation, donating your body to science and things of that nature. So all of that is in the healthcare power of attorney.
Okay. Now then, where does people always talk about do not resuscitate document? Where does that fit in this conversation?
I usually put that language in that healthcare power of attorney.
Okay.
So.
And that would clarify that, as you said, if I'm in the hospital or wherever, that what kind of sustaining life supports I might want.
Right.
Or not, correct?
Yeah. So essentially, you could either give your patient advocate is the person who is making that decision for you. You can give them total discretion as to what to do.
Okay.
Or you can just deem specifically as you want it. If you're in a vegetative state and two doctors kind of deem that you can function, but you're not really gonna, your condition is not gonna really reverse itself, then at that point, remove me from all life-sustaining equipment, medication, just keep me comfortable. Or that you have some people who says that by any means necessary, keep me alive at any cost. So anywhere within that range, and that's which you have a conversation with people as to what they're going to do.
Okay. Understanding those pieces, what is a will? Okay.
Well, a will, just kind of back up what probate is.
Okay.
Probate is when you pass away, you have assets and stuff. And what the probate process is it's the court organizes the process of transferring your stuff from the deceased into the name of the living. Okay, so that's what the probate court is for. A will is instructions to the probate court as to what you want to do. Some people have the misconception that if you have a will, you avoid probate. No, actually, a will guarantees probate. A will is just instructions. You've actually told them, this is what I want to do. This is how I want to carry out. You name a personal representative, and that's the person who kind of walks through and makes sure that those wishes are carried out. Okay, and the court oversees that.
Okay.
Okay, so that's what a will does. So if you pass away without a will, it's called intestate. So your estate still goes through probate, but the order of distribution it goes by the state statute, and so your will is pretty much already set in stone for you. It doesn't go the way you want. It could end up the way you want it, but the thing is you get a will, everything is distributed the way you want to.
Okay. Then the living trust, I guess my question is there any way to avoid probate whatsoever? Or do you, no matter what, you always have to go through probate?
Okay, well, you go through probate when you have assets that have to be distributed from the deceased to the living. Okay. So the way to avoid probate is to pass away. If you pass away with nothing in your name, then there's no probate.
Okay.
Okay. There is a process, there's a small process sometimes where debts have to be paid, because that's one of the things too, is that if you have any outstanding debts have to be paid before assets are distributed to the living. But what a trust does is it's a document outside of yourself, so it's not you. Mm-hmm. It's its own individual entity. So you draft the trust. The trust you name a trustee. Typically, while you have all of your capacity and you understand the nature of what you're doing, you are the trustee. You're the person who directs everything. Once you draft this document, it's its own entity. All of the stuff that you own, you assign to the trust.
Okay.
So what happens is you don't own anything anymore. Mm-hmm. Your trust owns it. Okay, so when you pass away, there's nothing in your estate. You pass away, your trust distributes everything. Now, what the trust also does is, if you lose capacity, you may have a successor trustee, and that successor trustee takes over in the same fashion as your power of attorney does. And that successor trustee has the powers to kind of do what you would have done too. That trustee also comes into play after you pass away. Their role takes place, and they distribute the trust. They distribute the assets in the trust in the same way. There's no probate in that process. Okay. And when you go through probate is public record. Okay, if things are distributed via trust, it's private. No one knows about it, and it kind of stays between you and the family.
Okay, so then let me think out loud. Too many people say, well, I don't have anything. So I don't have anything. All I have is a job, and I'm living check to check. I don't need a will. I don't need any of that. Do you agree with them?
Everybody has something. Okay, everybody life insurance is considered. Well, life insurance is one of those things that pass outside of probate. However, you have furniture, you have, and especially another thing too is if you have minor children, where you name another guardian. If you have a minor children, you're a single person. In the will is where you name who's going to be the guardian of your children in case you pass away. So the thing is you might not look at yourself as having a lot to distribute, but having a will makes the process a lot easier, a lot less expensive than just going through the entire probate process.
Okay. Okay. So then people like, I think it was like a number of famous people recently that had no wills or documents, or they had multiple documents. I think Aretha Franklin might have even
Yes.
had a document. Just curious, those folks had stuff. I mean, lots of stuff. What's just your thinking of why that people don't actually create documents?
Well, I think it's one of those things where you don't think that you're going to die right now. That's one of the reasons. And so that it's just one of those things you don't get, people don't get around to. Yeah, I've had people where in the process that I've tried to get to do estate planning and get their affairs in order, right in the middle of us putting everything all together, they passed away. And it ends up being a probate process. And the thing is in life, you're dealing with your business, you're dealing with your day-to-day. You just don't think that it's going to be you. It's the same, ideology as people don't buy life insurance. Sometimes it's a mental block of people think that if I do this, that it's going to cause me to die. I'm going to get sick and die.
You say that. I had a friend who believed that. It was clear her dad needed her to have a conversation about death. And she wouldn't have it. And I'm like, why are you not having that conversation? She said, Paula, if I have the conversation, he's going to die. And I said, girl, he's going to die eventually anyway, like the rest of us, but he needs you to talk to him right now because it feels like a conversation he wanted to have with her.
Yeah, it's inevitable. It's going to happen. Even if you don't know how you want things and you don't want it to be perfect, it's better that you make the decision as to what to do as opposed to having it done by the state law. So it's better that you do it. So like I said, there's the deceit in the estate part of it, but then there's also the living probate side, which is if you lose capacity, you may think your children are going to take care of you.
That's pretty
risky. They may not. You don't know. Have you had that conversation? What child would actually do it? And some people don't know. Okay, and you need to think about it. Is the child the person to do it? So you need to think about these things, because the other thing too, you never know when you're going to pass away. You also don't know if you're going to become incapacitated.
Right.
There's traumatic brain injuries and things of that nature. Who is going to be the one that takes care of me? If it's not done, then you have to go to court and let the court decide who is going to be, who that person is going to be, who's going to take care of my affairs, who's going to take care of my personal well-being. And so you might as well make the decision yourself as opposed to have it in a court proceeding.
Right.
Even if it's not perfect,
right,
you can change it, but you decide. Don't let the court decide.
Many of the people we service are caregivers of loved ones that are living with dementia, and we stress that very early on in that caregiving process that it's important that you all have the conversation about what people want and get the paperwork in place. Because once they lose capacity, it's not like you can go back and just grab it and bring it back. And then how do you then care for them if you don't have the right documents in place? And one of the things that many of my caregivers do, and I understand why they do it, is that they sign checks for their loved ones because they need to get stuff done, and someone needs to be paying for stuff. And oftentimes their names are added to the account of the loved one with disease. I don't know that that's the best way to do it, and there's some pluses and minuses. Do you have an opinion on that issue in particular, with me adding my name to a bank account that doesn't belong to me?
Well, first of all, the only person who can legally add your name to it is a person who has the capacity and understanding what they do so. So the thing is once that person loses their capacity, they can't really, they can't add somebody else's name to it in the first place. But just even as a practice, I would not, if I am in sound mind, the best thing to do is to not add someone's name to an account as a joint owner, because from a legal standpoint, that money is just as much theirs as it is yours.
Right.
And so if that person is sued, or I've even had, if you want to talk about a horror story, I had a client who added his son to his accounts as a form of estate planning that had just passed on to him. And the thing is, when the son got divorced, that father's money, it was essentially the money became a part of the divorce proceeding. So that's you think that's my father's money? No. When you add them on as joint owner, it's just as much theirs as it is yours. Okay. So you don't want to get that caught up. The best thing to do is to leave the money in your name, have a power of attorney. That money is always their money, and it can never be attached to that individual that you leave to it. They can make transactions for you, but it will never be attached in a lawsuit. It's not theirs. Okay, so that people want to look for the easy way to do it. It seems like that's easy, but there's a lot of pitfalls involved with that.
Okay, and I have heard that horror story a number of times. So if you were going to reflect on the essence of all the things you said, give me the 3 things you would want people to walk away with from this conversation. And then you also can tell us which of those documents, again, you think that we should have crafted.
Well, I believe that everyone, well, first of all, if you're dealing with if you're a caretaker for your parents, especially if your parents still have the capacity, they understand the nature of what you're doing, what they're doing, please get them to do a power of attorney and a power of attorney for healthcare, okay, while they have the capacity to do it. It's coming. I mean, a lot of times I know our parents, they need help, but they still understand the nature of what they're doing. Before it gets to the point where they can't make that decision, get those documents in place before it goes into court. I think those are probably the most important things. Also,
I'm sorry, let me clarify just the power of attorneys, including health, finance, all of it, just the durable powers of attorney.
Yeah, 2 documents: power of attorney, durable power of attorney, to allow to name a person to take care of their finances and the business affairs when they lose the ability to, and also power of attorney for healthcare.
Okay.
Name a patient advocate. Okay, have those documents done for that person while they still have the capacity. Talking about the decedent estate, once they pass away, looking at doing a will, okay, and a trust. Now, the thing is which one do you get? It really depends on what your desires are. Mm-hmm. If you have a real simple situation, a will may be fine. A will is simpler, it's less expensive to draft, depending on how you want things distributed, who you want it distributed to. A will could even though you still have to go through the probate process with a will, that's probably the simplest way and the least expensive way to go about it. And also it depends on the nature of your assets. Some people who have so-called a lot of money, if there's certain assets that pass outside of probate. If you have retirement plans, IRAs, and if that's the significant part of your estate, those have beneficiary designations on them already. And so those wouldn't be a part of the probate process anyway. Those would just go straight to the beneficiary.
Let me clarify. If I have a retirement account and I've identified who I want the monies to go to and in what portion, they don't have to be part of a will. Is that what you're saying? Or
well, here's the thing: is Remember, I said probate is the process of distributing your assets.
Okay.
There are certain things that aren't part of probate. If you have a retirement account, an IRA, a 401k, 403b, when you set those up, you name a beneficiary.
Okay.
Okay. So those pass by contract. So whoever you have on that, it doesn't matter what your will says. Those things will pass by whoever you put on there as a beneficiary.
Then you
Okay.
need to make sure they're up to date.
Yeah, you got to make sure that they're up to date. You need to look at that. So even if it's a person who has a significant amount of money, if the nature of the assets are retirement assets, sometimes a will cover them. It depends. A trust, if there's real estate involved, if there's minor children, grandchildren, if you have where you want to kind of hold on some money for grandchildren or children, if you have a person who's a child or a beneficiary who's a spendthrift and you don't want them to come into a lot of money all at one time and you want it to be doled out to them over a period of time, then you have a little bit more of a complicated situation. A trust will probably work better for you. So it really depends on the nature of the assets, what your desires are, whether to get one or the other.
Okay. I'm speaking with attorney Eric Holmes, who is an attorney, has his own business here in Southfield, Michigan. Eric, would you like to tell them anything else in terms of the best way to reach you if they're interested in talking to you?
Yes, I'm located in Southfield, 12 Mile and Evergreen area. I can be reached. My phone number is 248-355-9011. I can also be emailed at eholmes@ejholmes-law.com.
Okay, thank you for your time. And I wanted to share one other thing is that in addition to there being outstanding attorneys out there that can provide the support, there are a number of legal aid groups that will provide some free support in this arena. And I think it's important that if finances are an issue for you, that you should look up some of the legal aid groups because they can provide great supports to you also. Eric, thank you for the gift of your time. I promised you I wouldn't take long, but I think you gave us a good overview. And if people want more details, they can contact you or they can contact me and we can provide additional support. Have a great and blessed day and be safe. Thank you, Eric.
You do the same. Thanks for having me on.
You're welcome.